Welcome to the 2015 Current Issues Workers' Compensation Conference, brought to you by the law offices of Richard L. Montalbo and sponsored by Apple. Innovation for your world. LexisNexis, not just more content, but more efficient research tools. John Pinto of Structured Financial Settlements, MacroPro Coping and Subpoenaing Services, the Newton Medical Group, Dr. Michael Summer, the Eddington Medical Group, and the Renbaum Medical Group. For the first time, this year's conference was held at the historic and elegant Citizens Hotel in downtown Sacramento on March 20th, 2015. The Citizens Hotel prepared an exceptional morning brunch, with the day ending with fine wines from the Lewis Winery and the Schaffer Family Winery. Before we begin, you may wish to download the conference materials, which are available without charge at montalbolaw.com. Should you be interested in CEB, MCLE or QME credits, please contact the law offices of Richard L. Montalbo for terms and to receive your certification of completion. The opinions expressed herein are the opinions, legal interpretation and analysis of the presenters. The viewer of this video presentation is encouraged to review in its entirety the case decision or statute which is being discussed. The Current Issues Workers' Compensation Conference involved 4 separate panels and sessions of just over 1 hour and 30 minutes each, and qualifies for 6 hours of CEB, MCLE or QME educational credits. The first session will be Case Law Update with the focus on case decision originating with the WCAB. The presenter will be Richard Montalbo. Mr. Montalbo holds degrees in business economics and computer science and received his law degree from the University of the Pacific McGeorge School of Law. Mr. Montalbo is also the architect behind Current Issues Workers' Compensation Conferences and is a frequent presenter at various legal conferences and symposiums throughout the state of California. Mr. Montalbo is also the app designer of the iCalc, the only smartphone workers' compensation indemnity app calculator. Mr. Montalbo is also the author of the Work Comp Index, a topical guide to the law of California workers' compensation. Let's join our panel already in session.
How's everybody doing? Let me welcome everyone to the, I look out there and I see a lot of smiles, and I think the expectations are far in excess of what is going to happen here today. But I'm glad everybody's here. Let me welcome everyone. Every year I start working on this, believe it or not, in July. This year, I started working on a special project shortly after I completed my work on my book. So for the last 6-8 months, I've been working on something. We're going to have an announcement today that I'm kind of excited about. But let me tell you this, if I look out there after this and I see everybody go, this is the sign, okay? If I see everybody go like this, then I'll know that, obvious, I'll know, okay? What I'd like to do is just start out. I'm going to go pretty fast to make sure everybody has everything, because with our announcement today, that's going to take some time, and I want to get to the important stuff. Let me just tell you, I had a friend give me a word of advice, and this is what he said. He said 2 things. Do not spend your time at your conference hawking your book or anything else. And we're here to learn, not to do that sort of thing. So I'm going to make sure that we actually learn. Let's go through and make sure everybody has the materials today. Well, no, I don't want to do that. I want to go through the speakers and what the topics are. Of course, we have a case law update the first hour. Then we're going to transition to what I think is going to be a pretty special panel. I think it's special because the topic really hasn't been done. And one of the problems whenever you put on a work comp conference or any type of conference is coming up with new information. And some of I think this panel and the last panel are new. The middle one, you'll find out why we had to do it. But the second panel is going to focus on 3 items. Social Security disability, which I'll be honest with you, it was a little bit of a black hole. Now it's turning gray, but there's a lot of information that on the defense side we don't know. And Ben Helfman of the firm of Leap, Tesher, Zanzi, and Helfman, that is the firm, in my opinion, the firm up in Northern California. In fact, I saw Brian here too, and between Brian and Ben, they are probably 2 of the top applicant attorneys in the Redding area. On that panel, they'll be joined by Steve Chapman. And Mr. Chapman is kind of a affordable care expert. And so they're going to be discussing the crossover between the Affordable Care Act and workers' compensation. And they have some really great points to make. We're really honored to have Mike Sullivan here. Now, Sullivan on Comp, we all have the book, and this is what I say, this is the only hawk I'm going to do, and I'm going to do it for a competitor. I think everybody should have 3 books in their law library. I think everybody should have Hannah. Now, we should all have, Herlick and Larson and Sinclair and the CCCs and the CWCRs, but if you can't spend all that money, you should have 3 books. This is what I think. You should have access to the CCCs and the CWCRs, okay, because you have to have the case law. But I think you should have Hannah. I think you should have Sullivan on Comp. And then there's a work comp index out there that I think everybody should have. Of course, that's my book. And what we did in the work comp index this year, this is the only hawk, what we did was we went ahead and indexed Sullivan and the CEB. So not only do you have the CWCRs, the CCCs, the Labor Code, CEB, Hannah, Larson, it's all indexed and it's a topical guide. So you get all that information. It's a great one-stop shopping whether you know what the law is and you can't find the case or the reg and I put all the emergency regs in that became permanent with minor tweaks, but those are all in as well. Anyway, but Sullivan on Comp is a book that 4 or 5 years ago, it was out there, but it wasn't, but now it's really at the forefront. So Mike Sullivan's going to do CMS MSAs. We're done with that. Okay, in the afternoon, everybody's on their own for lunch. Of course, we have a brunch over here, and I think that'll go through the first break. But we'll have the espresso bar here all day, and I'm listing why you should be here, because everybody now knows that we're live on the internet, and you're all thinking, well, why did I spend money and take time to come down here? This is why. The food, the espresso, the materials, the giveaways, the wine tasting. See, I just went through the fun stuff the course of the day that everybody's here for. And we have 2 great wineries at the conclusion of today. Lewis Family Vineyards, which is, we're going to be sampling their Chardonnay. I'm not a big Chardonnay guy, but I think everybody will like it. And then one of my favorite big, bold Napa Valley Cabernets, we're going to have Schaefer, 2012. So if you're into wines, you'll be, I think, delighted. If you're not into wines, you should still come down and have some. Let's talk about the first afternoon session. We're doing, once again, Guzman Ogilvie. And it's got to be done, and I'm going to tell you this story. I was at the DWC. I was there listening to a case law update from somebody that I respect. And this gentleman said, I have a couple of, and I don't think they had the most important Ogilvie cases. I have a couple of Ogilvie cases, but I'm not going to go through them because post-1113, Ogilvie's dead. Now, just by way of a show of hands, how many people believe that? Okay, see? Bingo. I had people turn around and look at me, and I just kind of rolled my eyes like, wow, it is not dead. In fact, it's become something bigger than Ogilvie. It's really, and they coined the phrase in a couple of the cases, Ogilbuff, because it's really a LaBeouf argument now that just translates directly over. But on that panel, we have a couple of gentlemen that have spoken in years past. And this is what I would say about Jake Jacobsmeyer. He's one of the top. Whenever I get one of his emails, I don't care if it's 10 o'clock at night and I'm dead tired. I'm so insecure about somebody knowing something I don't, that I don't go home and I read it, okay? So if you don't get his email, you should try to get it. He'll be joined by Mark Gearhart. Mark is an applicant attorney down in the Bay Area. Mark I've spoken on panels with him. I've had cases against him. Every time Mark Gearhart's involved, and he'll hate that I said this because I'm setting him up for a very difficult life, I bring my A game. And I'm going to say this, that if you are an adjuster and you're sending out files and Mark Gearhart's on the other side, it's not fair to send a 1-3, even a 7-year in there attorney. He's not a true believer, but he's very, very competent, very, very good at what he does. The last session, we have some newcomers, and we have a pretty neat topic, 4662, which is the 100% case, along with apportionment. On this panel, we have Mike I'm going to kill his name, Giacchino. I think that's correct. But he is a capital partner with H&B in Oakland. There's not a harder working attorney out there. This guy is a worker, and he's always prepared, and he does just an exceptional job. I've heard him speak in the past, and he does a real good job. They'll be handling 4662 and apportionment together. He'll be joined on the applicant side by Jason Marcus. Now, Jason's kind of a young gun compared to everybody else that's speaking, but he has been somebody who's showing up quite a bit at the COG conference, and the guy's good. Well, he's great. We had a phone conference, and this is no BS. I tend to talk too much, but I shut up and listened to him. And at the end, I told him I feel like applauding, because he just really was succinct and to the point. He told us what he thought, and it was really good. Of course, his father spoke last year, Mark Marcus, and Jason obviously takes after his mother. So anyway, no, Mark's a good guy. Okay, so that's the day's events. Let's make sure everybody has the materials, okay? This is why you should come. Now, if you don't come, or if you want MCLE or specialization credits, if you log onto my website, you can download these for free, and you can watch the whole conference for free. You know, this is not a venture capital venture for me. This is just, anyway. So you get the materials. And what I'd say about this, especially my writings, they're source documents. This is all the work that I did this past year that went into the book that I was working on, okay? The Work Comp Index. So, oops, I said that again, didn't I? Anyway, so you get the materials, and I think this will probably outlive the conference. Also, you get the PD rating manual. And what makes this special is the appendix. Take a look at it. There's a lot of information that I include in here that's not part of the original schedule, okay? If you're an attorney, and I've heard this story, 4 or 5 years ago, I heard from somebody, hey, so-and-so came into court and flipped your deal up and said to the judge, well, it's in the schedule. Okay, what's in the appendix are helpful items, but they're not what the state of California came out with. You should also have, and I just lost it, here it is. You should also have the flash drive. And what's really cool about this is it's a storage device that you can erase. If you didn't get a flash drive, there's some out there. I see people looking for a flash drive. But, you know, I get so many calls. I carry one of these around with me all the time. I get so many calls after the conference about, hey, Rich, I get your flash drive, and it doesn't work. And I feel compelled, well, first to talk them through it. But I always think, oh, man, they come to my conference, and they want the flash drive.
They can pick them on the way out.
Okay. Okay, so we have some out there. They came to the conference, and forget about all the education, all the training, everything, they wanted the flash drive. And invariably, you know, I say, well, if it doesn't work, just call me back, but it always works. Look at, folks, if you take it and you pop this out, that's a USB port, right? What's USB stand for? Universal Serial Bus, right? Not bust, bus, okay? That's how computers talk to devices. If you take it and put it in your USB port and it doesn't work, hey, guess what? Flip it and it'll work, okay? So, but the nice thing about this is erase it and look it. You just put it in your, I mean, it's a cool little storage device. I use it all the time. Also, 4 years ago, I guess, I did this slide calc. And if you take a look at it, this is what I tried to do here was, if I was going to the board on an 8.5 by 11, I had 2 goals or objectives. I wanted to not carry a bunch of charts. On an 8.5 by 11, I wanted all the information that I felt that I needed to quantify it. If it was on my desk, I wanted a color that I could grab and find it. I didn't want to look through a bunch of things. But also, I wanted to be able to read it without my reading glasses on, because I hate grabbing those damn things. So on the front, you have the PD. On the back, you have everything. You've got TD, you've got life pension, you've got life expectancy, you've got a summary of job displacement, and you've got death benefits. And there's a lot of explanation here with cited to the labor codes. So you should have that. Now, at this point, I think what we're going to do is I'm going to have something plugged in, and we're going to watch something. And just remember, if you go like this, I'll know, oops, okay? Throughout the course of human history, there have been significant events along the road to modern society. One such milestone was man's quest for fire. And of course, the natural consequence of injury by fire. Next, fire was brought to the workplace. But lessons were learned. But then, of course, industrial injury by fire occurred. As a result of industrial injury by fire, man's next quest ended with the California Permanent Disability Rating Manual, a document by which industrial injuries and resulting whole person impairment is analyzed, quantified, and ultimately converted to a monetary value. The next logical step was, of course, the indemnity slide calc, a device that allowed complex workers' compensation formulas and algorithms to be converted simply into monetary values given a particular date of injury. And now, perhaps the final step in our journey, introducing the iCalc. Let's take a moment and see how the iCalc works. Essentially, it is a slide calc for any personal electronic device, including iPhones, iPads, or Mac computers, as well as being adapted to run under either Google or Windows OS. Like any app, the program, once downloaded, performs flawless calculations of indemnity without the need to be connected to a server or the internet. Let's take a look at just a few of the features. First, you'll note that along the bottom, icons are present for PD, TD, life pension, life expectancy, and death benefits. Let's start with permanent disability. For example, let's say 60% for a 2005 date of injury. That would produce $77,275. And you'll note that additional comments, explanations, and annotations are just a click away. Next, let's look at TD. Here the iCalc provides maximum and minimum TTD earnings and calculates the appropriate rate, as well as providing the reported SAW and percentage increase for a selected calendar year. But there's even more. The iCalc also handles the calculation of life pensions, providing the appropriate benefit for a given year based on the percentage of disability selected. Here also annotations and additional explanations are provided. Calculation of life expectancy is also part of the iCalc. The iCalc uses the 2008 U.S. life tables, but will be updated as more current data becomes available. Last, calculation of death benefits is also part of the iCalc. Here the correct death benefit is displayed for a given date of injury and number of dependents, partial or total. The iCalc has presently been submitted to Apple for review, comment, and is anticipated to be available at the App Store for downloads by the end of March 2015. The iCalc, making the complex simple.
The indemnity calculator, iCalc, and the iCalc are trademarked and copyrighted with all rights reserved and is the property of the law offices of Richard L. Montalbo. All use or likeness of the phrase or word iCalc or duplication, reproduction, or use of this application without the express written consent of the law offices of Richard L. Montalbo is expressly prohibited. The iCalc is available for purchase with the express consent of the law offices of Richard L. Montalbo at the App Store.
Oh my God, oh, a 2. They told me they were going to rate it. I got 2 10s and a 2. So I don't see anybody doing this. Let me tell you, this past year between the book and the iCalc, I was pretty busy. What do you guys think?
Good, very good.
Okay, we're already working on the iCalc Plus. I wonder what that is going to do. So next year, what? Oh, didn't you hear what it said? We're converting it over to, Google and Windows. So that'll cover all smartphones. Listen, I'm not here to sell this. Let me just say this. This will surprise everybody. Pricing on this is gonna be cheap. You know why? This is what I would tell you. I've been practicing for 25 years now, and the work comp community is a pretty good community. You know, we might fight, and there's a couple of errant son of a guns out there, right? But by and large, we have both sides of the work comp community here, and I want to be careful what I say because I have clients here, and I don't want them to think I'm a candy tush. But we fight, but we fight fairly, and the ones that don't fight fairly, we look at them and we go, "Hey, I'm not so sure that we like you," and they don't stick around forever. They just don't. So it's going to be very. Let me ask this. First of all, how many people would even want that on their iPhone or a smartphone or Android or? Okay. I mean, and let me also say this. The gentleman's here. A few years ago, I was at the board, and I've been doing my PD manual and then my slide calc for eons. And I was at the board, and somebody came up to me in front of some other attorneys and said, "Hey, you've got a wrong number." And let me just say that is a flippin' nightmare. Okay, he and I have a deal, and he's here. I'm not gonna say who he is. We have a deal. Every time I go to the board, I didn't have a wrong number. I want to say that 3 times. I did not have a wrong number. My numbers have never been wrong. Every time I go to the board, I walk up to him. I make sure people are around. I go, "Hey, how's the slide calc?" And he has to say, "Oh, it's perfect. It's right. Everything's good." But in 20 years, I've not had a wrong number. Right now, I have the only beta version of this, and I'm going to pass my phone around. Feel free to bump it and steal all my data. And you can play with it and see how it is. Whenever you design an app, one of the things that you cannot do is ever release it before it's ready to be released. And my undergrad was in, economics, MIS, computer science. I worked for IBM. And we wrote this in C, and then we compiled it. And there's nothing worse than having a program go out there that is an absolutely 120% accurate down to the penny. Because if it's ever released, and that's why I have one copy on my phone. Right now we've submitted it to Apple, and they go through. Part of the reason that we don't have so many bugs on the Apple platform is because they want the source code, they want the compiled code, and they go through the program, and they make sure that there's nothing embedded in it. You haven't done something clever. So that's the advantage about Apple. They really control everything. But I'm going to go ahead and just pass my phone around, and you guys can play with it and see how it works. And you know what? We're going to start with Debbie Stopper, because Debbie was the one that came up with the idea 20 years ago or something that, Rich, this is pretty boring stuff. Maybe you should have an espresso maker, a barista in here. Debbie didn't even want to take a look at it. Yeah, just roll around. It has everything on it. Okay, let's get started. Everybody's here for a case law update, so let's start with the case law update. Whenever I discuss an area of law, what I like to do is I like to teach an area of law whenever I do my case law update. The first area I want to talk about is injury AOE COE. I don't care if you're talking about the going and coming rule, the special missions exception to the going and coming, the personal comfort doctrine, the commercial travelers rule, name it. Intoxication. One word about intoxication, because we have a lot, or drug usage, we have a lot on an AOE COE basis. We have a lot of adjusters here. You need to understand that just because somebody's intoxicated, that it may give the defense attorney something to argue about, but you seldom win those for 2 reasons. If the injury is catastrophic, say there's a death, the judges always try to help out the minor dependents. They just do. That's what judges do at the WCAB, and under 3202, I think that's appropriate, okay? So what evidence do we need if we have an intoxication defense on the defense side? Let me tell you what I show up with. I've got an accident reconstructionist, and he has to say, but for the intoxication, but for the drug use, that accident never would have occurred as and when it did. That's the level. So it's a tough one to overcome, okay? I'm probably also going to have, besides that, a toxicologist, because they're going to be able to convert whatever the blood workup tells us. Okay, so just be aware of that. That's Labor Code Section 3600. But when you look at this whole area of law, there are only 3 elements to AOE COE, and they're all analyzed, whether it's statutory or otherwise, right? I'm going to try to boil this down so everybody understands it. Only 3. The first one's a throwaway, and we talked about it last year. Consensual relationship. Okay, you know, that goes without saying, right? There has to be a consensual relationship between the employer and the employee. You can't have somebody come in your backyard and dig a hole and say, I hurt my back, okay? There has to be a consensual relationship. Last year, we talked about the prisoner who was in the prison and a cook. And they said, no, that was not a consensual relationship. They were requiring him to do that. Therefore, it's no AOE COE, and they had an ordinance that precluded it. We talked about that last year. It's in your materials under AOE COE. But the other 2 tests are the 2 important tests. No matter what area of the law you're in on this topic, you want to look at benefit conferred. Was there benefit conferred from the employee to the employer? Okay? The second one is control or right to control. And you're going to see the Acosta case, which is a Supreme Court case, California Supreme Court case. They focus on the control test. And it doesn't have to, that doesn't mean that the employer has to exercise that control, but they have to have the right to exercise that control. And what they said in the Costa case, and that was a labor case, I'll just go through it real quick. It's in the box on the your second page. The Costa case was a labor case. It was newspaper delivery people, and the issue is whether or not hours and standards applied, and they were making a claim for it. And what the court said there was that the ultimate test on the control test is whether or not you have the right to hire and fire. Now, I think I understand that that's probably the important test, but I'm on whether or not you have control or right to control. The way that I analyze all these cases is you look at the totality of the factors. You look at, you know, how they're paid, what they do, is there a special license involved? Restatement of seconds, the second in agency has a whole list that you're going to go down. Just because somebody says you're an independent contractor, you have a contract that says they're an independent contractor, is not sufficient to vitiate any employment relationship and liability that flows from that. So be aware of that. Let's talk about so those are the 3 tests, 3 elements that you have to have. There's one other case that I want to talk about real quick on this before I go into the cases I have here, and that's the 2-pronged test of EZZY, EZZY. This was a California Supreme Court case, and what they said was, in determining whether or not you have the presence of these factors, you want to look at 2 things. Subjective, whether or not the applicant believed it, and objective, whether or not a reasonable person would believe that there's benefit and control or right to control. Okay, let's talk about the Young case. That's the first case in your materials. Mr. Young is a correctional officer. He gets up one day, gets out of bed and says, you know what, I'm going to exercise. I'm a supervisor, I need to lead by example. He's doing some really, really rigorous exercises. What are they? Jumping jacks. And he hurts himself. Now, without knowing anything more, is that AOE COE? Okay, the applicant attorneys are saying yes. The defense attorneys at this point should be saying no. So we have a conflict here, okay, over whether or not that is. Ultimately, they said it was within the course and scope of employment, and they looked at a couple of factors. Number one, as a supervisor, he testified that he encouraged the subordinates to be involved in maintaining good physical shape. There was also evidence that they practiced takedown maneuvers that required that they be in good physical shape. Now, I want you to think, good physical shape, that's a benefit, right? But the employer was not controlling how they did it, but they encouraged it. So what the court said was, we're going to imply from that benefit that we want that there's some measure of control. And they ultimately found it AOE COE, even though this was taking place at home. Now, the court went on to say the employer might be able to limit that liability by providing a prescribed method and time for that exercise. Now, we have a lot of cases out there, and I want you to think about this whole area of case law dealing with sports. The guy that goes out and plays basketball and says, well, I have to stay in shape. Or goes out and, I don't know, skydives and says, I have to increase my courage. Okay, here's the issue there, the way that we should look at that. And it's pretty simple. If it was an employer-sanctioned or directed activity, it's going to be within the course and scope. But as a general rule, it will not be. Okay, and that's how all those cases come down. So that's the broad area of the law there. Let me go through some of the cases that I have in here. I already mentioned the Avila case, but you see the Campos case? This is a classic outside of the course and scope. What happened was the employee went home. 5 hours later, she came back to the workplace where she was sexually assaulted. The issue is, was she within the course and scope of employment? The critical factor was, why did she go back to the workplace? If she'd gone back for the employer, it might be within the course and scope. She went back to get her husband's keys, and they said that's not within the course and scope. This Golden State Health Center case is troubling because, and I've never understood this, judges will put in their opinions sometime that they have questions about the credibility of the applicant. But then they'll go ahead and rule in favor of the applicant. And that's what happened here. It was a horseplay case. It was a dog pile. The evidence was clear that, the evidence from the applicant's perspective, testimony was clear, that he didn't consent nor did he start the horseplay or the dog pile, but he was injured. The court found that credible and said, listen, you're within the course and scope of employment. They found that industrial. I have a commercials traveler case at Swift Transportation. There's no surprise there. I'm just going to include it in my book. Truck driver, long-haul truck driver, got beat up during dinner. You know, he should have just eaten and kept his mouth shut, perhaps. That was within the course and scope. Harsh, huh? And I have one special missions case that you should be aware of. On the next page, I've got this Alexander FedEx case, and then I also have in the box that Ruiz case. They both stand for the same proposition, which is just because the employer has an agreement that says you're an independent contractor, if the activities between the two, the relationship, demonstrate benefit and control or right to control, it doesn't matter what you call the relationship. And in the Ruiz case, what they did was they asked everybody to have their own bank account, DBA, private insurance, the whole list. But they said, hold it. You're exerting control or right to control, therefore it's an employee-employer relationship. Okay, let's go. See how fast I'm going? I'm going to make it through this, maybe. Today we're going to discuss apportionment in the last session, but I'm going to give you my overview because I think there's probably not an area from the defense perspective that we don't work on and litigate more than apportionment. We save our clients a fortune these days. Apportionment is certainly a defense issue, and I think sometimes the doctors don't quite get it, and perhaps they overcomplicate it, but it is complicated. This is the way I want everybody, for 5 minutes, I'm going to tell you the entire law of apportionment. If you follow these, you will understand the law of apportionment. First of all, in your mind, you have to differentiate between apportionment of liability and strict legal apportionment of disability, permanent disability. Apportionment of liability means that there's no question as to whether or not the applicant is entitled to these benefits. It's who's going to pay. And that's just a substantial evidence, equity, factual determination. And, you know, it may be litigated, but usually it's negotiated out between attorneys. Strict legal apportionment is what I want to go through. Strict legal apportionment, this is what you should know about it. First of all, it's clear now. And in 2008, I spoke at CAW, and there was a riot on the stage because I said what I'm going to say right now, that apportionment is direct causation. The employer is only liable for that portion of the PD that is directly, arguably, solely and exclusively caused by the subject industrial injury. Now that cuts both ways, and I'm going to go through that in a minute, but it's direct causation, and that was not the case prior to SB 899, okay? So the first thing I want you to realize is direct causation. Then there's only three other things that you have to know, and I'm going to run through them real quick. Number one, the defendant has the burden of proof. That's the Pullman-Kellogg case. If the defendant doesn't meet the burden of proof, guess what? For two reasons, we have the burden of proof. Partly because of Pullman-Kellogg that says that we have the burden of proof, but also I've never gone to court and had a judge say, hey, Mr. Montalvo, I see that you didn't meet your burden of proof on causation of apportionment to non-industrial disability. So I'm going to give you a continuance so you can go out and develop that record. You see my point? So as a practical matter, the defendant better show up and he has the burden of proof. Simply put, the burden of proof, a lot of people don't understand this, the burden of proof is always on the party that benefits, this is how simple it is, benefits from the affirmative of the issue. Think about that. Whoever benefits from the affirmative of the issue has the burden of proof. Now, that burden may shift, but that's who has the burden of proof, okay? So number one, defendant has the burden of proof. Number two, there's only two labor codes that apply. They are 4663 and 4664. I'm going to run through them real quick. What are the elements? Let's start with the one that's most difficult. That's 4664. It's difficult because of the elements. Number one, under 4664, you have to have what? A prior award. That is a stipulation or an F&A. It's an award of PD. It is not a compromise and release. A compromise and release is what? A compromise of issues, a release of liability. There is no PD award. I know that some defense attorneys think you can put a string in the order. Most judges will not approve that. I know that there's a panel decision out there where you could call him a judge, where Dr. Newton was able to convert an old AMA guide or an old guideline case to AMA, but those are outliers. As a general rule, you have to have a prior award. Okay, number one. Number two, the second element is you have to have. Boy, I'm on a roll here, aren't I? Oh, you have to have same side of the fence. Okay, so number one, you have to have a prior award. Number two, you have to be on the same side of the fence. And what that means is they either all have to be old guideline cases or AMA cases. It's becoming less important, but they have to be on the same side of the fence. It's too difficult to take an old guideline case and bring it over. But that doesn't mean you don't have apportionment, because we have 4663. And then the last element is you have to have overlap. And generally that's going to be the same part of body or same region or part of body. But also think about this. Under the AMA guides, question whether or not you can get a 4664 where the original rating was under, for example, the DREs, and then later it's an ROM. Okay, so those are the elements for 4664. It's too difficult. I don't worry about it that much. It's nice. The only reason that we might want it is because of the presumption, okay? There's no medical rehabilitation any longer under this system. But what's the easy one? The easy one is 4663, which is apportionment to causation. Let's go through the elements there. And every time I read a doctor's report, this is what I'm looking for. Number one, does he have a full, complete, accurate medical history with a proper diagnosis? Full, complete, accurate medical history with a proper diagnosis. If it's not full, if it's not complete, if it's inaccurate or wrong diagnosis, guess what? His opinion is not going to constitute substantial evidence. Number two, that opinion has to be expressed in terms of reasonable medical probability based on his education, training, and experience, and understanding of the facts involved in the case or presented to him by way of a hypothetical. So number two, reasonable medical probability. The last element is the one where the doctors often make mistakes. And the last one is that the doctor has to explain the how and why. He has to have a rational thought process. He has to connect the dots. These are the phrases that the cases tell us, okay? So he has to explain why he's doing what he's doing. Now that's to establish non-industrial causation, okay? That's the Escobedo substantial evidence with some panel decisions that come up with those rules. But it doesn't stop there, because the doctor is going to give us a percentage. I would argue, and there's a couple of panel decisions that suggest this, it came on early on, you don't see much litigation in this area. If the doctor says 15%, and the defense attorney says, well, doctor, why isn't it 10%? And the applicant attorney says, well, why isn't 20%? And they seek to have that overturned. Let me tell you, the actual percentage, and you have to separate this in your mind, the presence of non-industrial causation is a substantial evidence test. You have to go through all that. But once you establish non-industrial causation, at that point, all the doctor has to do is express an opinion that is not arbitrary, capricious, or without rational basis. In other words, that's a pretty high standard. So whatever percentage he applies is probably going to be upheld. Okay, the third thing you have to know about apportionment is Benson. And this is what I say to the doctors in the audience. Benson allows, it's the best example of direct causation that we have, or one of the best. Benson says that you're going to rate separately the PD for each individual injury, okay? And why is that important? From the defense perspective, Benson has probably saved us more money than any other case out there, because I'm going in every time that I see a specific and I'm arguing CT. Every time I see a CT, I'm chopping it up and finding some specifics, because I want that rated individually. The exception to the Benson rule is the phrase inextricably intertwined. And this is what I say to the doctors. You don't want to be, number one, you get paid the big bucks to not be Mr. Inextricably Intertwined, okay? I'm not saying that it doesn't apply and that there's not examples where the doctor can't reasonably, ferret out between the two industrial injuries. But if you're a doctor and you're known as Mr. Inextricably Intertwined, which is an easy way to get out of addressing the issue, then think about the medical legal procedures. It's okay to be on either side of the fence as a doctor unless you want to be busy. Why? Because you'll never be agreed to as an AME. You'll be the first bumped off the panel QME by one or the other side, and you will be, your only hope is an improper who timely selects you. So you're not going to be very busy. Before we leave that, let me just, I'm going to wait until I get to Navarro to make another point. Okay, so that's the law of apportionment. Now, there's one other thing that I want to cover with you on the law of apportionment. That has to do with apportionment under Labor Code Section 4662. That's the 100% case, or statute, loss of hands, loss of eyes, use thereof, lower extremities, or mental incapacity, or according to the fact, right? There was a case a number of years ago, Sanchez, that said that apportionment under 4662, you were not entitled to apportionment under 4662. And the applicant attorneys, and it was a split panel decision. Now, the dissenting opinion was Jim Cuneo. And I've always, you know how I've been somewhat successful as a defense attorney? I figure out who the really smart guys are, and I follow their path. And Jim Cuneo, every time he wrote an opinion, I read it multiple times because he made excellent points in all of his opinions. In the Sanchez case, he wrote, and I'll get the site if you guys want it, he wrote the dissenting opinion. And he said pretty much what DeFresney says. And I've used this analogy, and I want everybody to listen to this. Because the defense attorneys need to understand this as well as the applicant attorneys, because there's flaws on both sides. And you have to read all the case law to understand this. Picture this. You have, and we're thinking about a 100% case, 4662, because it only applies where they're 100% disabled, okay? You have three pictures. The center picture is empty. It represents the applicant. It's empty because there's no disability. To the left is a picture full of oil. That represents non-industrial causation. To the right is a picture of water. That represents industrial causation. Now, if you hang on to this, you're going to figure this out because but listen, so you have two pictures, one oil, non-industrial, water, industrial. You take the picture of oil, which is non-industrial causation, non-industrial disability. You pour it into a third. It sits there. Now, this applicant's able to work because he has a 30% disability. It's non-industrial. Nobody's paid him for it. Okay? But guess what? He has an industrial injury. That's the water. And you start pouring that in. What happens to the oil? The oil starts to rise. It rises, it rises. Now, he has the industrial injury. He's permanent and stationary. And he's 60% disabled. 30% industrial, 30% non-industrial. It's 50-50. What's his award? 30% industrial. The employer does not pay for the oil. Okay? You keep filling. He has another injury. You keep filling. Or he has a single injury. I don't want to bring Benson into this hypothetical. You start pouring. The oil keeps coming up. Now, this is what the defendants say, and this is wrong. The defendants say, hold it, you can never have more than 100% disability. That is wrong. You can never have more than 100% disability award. Okay? What happens? The defense attorneys want to say it's capped. You filled it up, you've got that 30 at the top that's non-industrial, and you've got the remaining 70% that's industrial. That's true. You don't have 100%. He might be 100% disabled, but the employer is only liable for that 70%. But what happens is you keep filling it. The oil, because it's not capped, dissipates. It comes over the side, it runs out. Eventually, and we have two cases discussing this in the materials, eventually the applicant becomes what? 100% disabled solely, exclusively, and directly because of the industrial injury. So in that situation, you do not have apportionment. Does everybody understand that? So on the defense side, you should not say it's capped. On the applicant side, you should not say there's no apportionment. Okay? So that sets everybody straight. Any thoughts? Anybody want to argue that? Because I've got sights, ladies and gentlemen. No, I think that's an accurate statement of the law. Okay, let's talk about Dufresne. Dufresne, I can't take credit for this. This is a case that came down that I wasn't going to include, and Jason Marcus brought it to my attention, and I read it, and I go, wow, it touches on everything. Take a few minutes and read it, but I'm just going to go through the highlights on this. Here's the issue. You have an AME, both psych and ortho, who say that the applicant's 100% disabled, but they both say there's apportionment to non-industrial causation. You have a VR expert who says the applicant's 100% disabled, but doesn't say that it's solely exclusively the result of the industrial injury. So what did the court do? The court applied apportionment. Again, the employer is only liable for that portion of the PD that is directly, causally, and arguably exclusively the result of the industrial injury. Okay? So that's Dufresne. Hey, I've got a couple of attorney's fees cases you should be aware of. First of all, you know, we had a major change as of 1/1/13 on 4064 attorney's fees. That was the section that we always used to get blindsided and crippled on. You know, I tell my clients under the old section, if you want to play, you got to pay, and the payment's going to be the attorney's fees. We had some defense attorneys that during that phase that were clever, and they would take these statements under oath. What the flip is that, ladies and gentlemen? Statements under oath. Number one, are they admissible? Maybe for impeachment purposes. Generally, these people were not represented. I mean, come on. And I used to think these defense attorneys that were doing it, wow, good billables if you can get them. But I don't know what the value, other than if you have it on delay and you think you're going to accept and you want to document your file, maybe there. But otherwise, not as part of the litigation process. But in 1/1/13, 4064 was changed. Prior to that, if we filed an application for adjudication of claim, we had to pay attorney's fees for the whole damn thing. After it, they changed it. The attorney's fees provision is limited to filing of the DOR and the issues involved with that DOR. Okay, so it's a whole different story. What the San Francisco State University case stands for is that the new version of 4064 post 1/1/13 applies retroactive regardless of the date of injury. Okay? I also put down there in the box the Hernandez case. And what's important about this case is that not only did you have to pay attorney's fees for the underlying case, but you had to pay an attorney's fee where the applicant attorney was fighting with the defense attorney over the hourly rate. Just a quick comment here. In 25 years, I have never litigated 5710 fees. And this is for the, number one, it's not cost effective. So if you have a defense attorney or if you're an adjuster that says, oh, we're going to litigate it, you know what? You don't want to send that file to my office. I'm just telling you. This is the way that attorneys handle that. You get on the phone and you say, listen, we have a problem with your travel. We have a problem with your hourly rate. And they talk about it, and it's resolved. It's just not cost effective to litigate a few $100s. I'm going to charge you more than that to open the file. Okay, probably not. But just be aware of that, okay? Okay, so that's the attorney. I have a FEHA case. This Kaiser case on page 7. What's interesting about that, and it's not workers' comp, but I have to read everything. What's interesting about that is the way that they interpreted what is required for severe and pervasive, for sexual harassment to be actionable. And honestly, if you look at the top of page 8, what the court actually wrote, citing the Hollister case, you know, I have 3 daughters, and I can tell you this. This is what the court wrote. I just shook my head at this. It said the court wrote, a hand on the thigh, a kiss on the lips, a pinch on the buttocks may be insufficiently abusive to describe as severe when they occur in isolation. Yeah. I don't agree with that. That's in the opinion. You know, that's just, I think that's representative of a very old and tired judge. That, you know, I don't mix words. Anyway, let's talk about death benefits. One of the things you need to know about death benefits is if you get a PERS death, dependency death payment, that on the WCAB side, we're entitled to a credit. Okay? So be aware of that. But the flip side is, just because you receive that PERS disability or that PERS dependency death payment, it doesn't mean that you don't have a WCAB. It just means you can't double dip and you're only going to get one. You're only going to get the higher of the two, less the credit for the one. Let's talk about discovery. First of all, the Solano case is kind of important. We should be aware of it. And it's being misquoted by members of the bar. It does not stand for the proposition that the defendant gets to choose the interpreter. And let me set this up for you. How many times has this happened? We go in and we take a deposition, and the applicant says, C. And the interpreter says, the applicant has just agreed that blah, 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 and he's had this out here, and blah. And you look at the interpreter and you go, wow, you got all that out of C or the converse? You ask a question and the applicant talks for 30 seconds and the interpreter looks and says, no. What do you do with that, right? So this is the importance of the Solano case. What it stands for is whoever notices the deposition. This could be important if you're talking about precipient witnesses. Whoever notices the deposition gets to select the interpreter. Okay? Okay, let's talk about exclusion at the deposition. The next case is County of San Bernardino. What happened here is the applicant filed a psych claim. She shows up at the deposition, and the source of the psych, which was her supervisor, shows up. He's the employer designated or selected witness. The applicant starts to cry and has an emotional outburst. Now, what's critical here, well, the applicant attorney filed for a protective order. What's critical here is that there was evidence, cause and effect. They had a medical report from the doctor that said this was a cause and effect. Without that, I don't think it's sufficient, okay? And they went ahead and granted the protective order in that. But what they did say was, that doesn't mean that the employer doesn't have an absolute right to be represented at the depot. It just means that the employer should select somebody else, okay? If you take a look at my box, because I'm a defense attorney, that Ura case is just the converse. The big, you differentiate the two by noting that there was no medical evidence. So just what happened in that case is the applicant said, I feel intimidated. And when I read that opinion, what went through my mind is, well, good. You should feel just a little bit intimidated because you're going to be, forthcoming. But the applicant felt intimidated. They sought a protective order, and they said, no, you're not going to get a protective order. Okay. Hey, if at any time there are questions, or somebody wants to make a comment, or somebody wants to disagree, those are all fun things to do, and it makes the time go a lot faster. Hey, how about that iCalc, huh? Okay, let's talk about the Babar case or Babel case. This is what I want everybody to know about discovery, about surveillance. And I want to see this by way of a show of hands. How many people believe this? The defendant has got to, regardless of whether or not there's a demand or not, has got to has got to send out a copy of the surveillance right after the applicant's deposition. How many people believe that? It's absolutely, if you don't do it, it's going to be excluded. Anybody? Anybody? Nobody. Okay, good. How many people believe that there's no way to get surveillance in if it's not disclosed at the time of the MSC? Anybody? Okay, we've got some applicant attorneys that say it absolutely does not come in. Okay. Okay, I'm gonna tell you what I think the law is on this, and it's gonna surprise and amaze maybe. This is the way that you ought to look at surveillance. Number one, it absolutely falls within privilege, but the privilege doesn't protect it. It absolutely is work product, but you need to think about work product. There's qualified and absolute. It enjoys qualified privilege, so you're never going to absolutely, as on the defense side, not have to produce it. So what's the issue? The issue is timing. When do we produce it? Now, you'll see in the box, I say the following. I can't imagine a time where there's not some way to get in relevant surveillance. I don't care when you disclose it. You know why? Because we have a whole line of cases out there that say that the WCJ should not foster a fraud. And so it should come in as rebuttal. Now, here's the way that I look at surveillance. I never disclose it before if it's relevant. If it's crap, come on. And I see a lot of crap surveillance. And I want to make this comment. There is some fraud in the work comp industry. It's not rampant. There's some malingering. It's more significant or substantial, because I believe if you identify, this is the economist in me, if you identify the costs, the benefits, and the incentives, you can predict human behavior. And what do we do in workers' comp? We absolutely provide monetary motivation for people to say that it hurts. And if you think it's otherwise, I don't care which side you're on, you're just wrong. And that doesn't make, applicants bad. It makes them human. And that's the truth, okay? So this is the way that I look at surveillance. If I have great surveillance, I never disclose it before I take the applicant's deposition. I enjoy relationships with certain applicant attorneys. I'll discuss this with my client ahead of time, and I'll say, listen, what I'd like to do is I want to close it. I'm talking to my client now. I want to close your file. I think this surveillance is relevant. I don't think it's going to destroy the case, or I think it will have a substantial impact on the case. This is what I want to do. I want to make sure that counsel for applicant knows that his client better tell the truth. And that's all I say. Make sure that your client tells the truth. Or I may say, this whole thing's wrong, and I'm quiet. Those are my two options at deposition. I don't disclose, or at least I tip my hand, and it depends on the applicant attorney. If I have a strong relationship, I go to my client and I say, this is what we want to do so that we can close it, or I keep my mouth shut. Following the deposition, I have a decision to make. Do I disclose it now, or do I hang on to it? Generally, I wait until after the AME or PQME examination, because I want the applicant, if they are lying, I want the applicant to do it a second time. Concurrently, I recommend, and I write this all the time, I think we should do an additional 3 days of surveillance over as many weeks. You don't stack it up unless you're getting something great, right? Because you know what the applicants say. I always disclose it, and there was a case that came down 2 years ago. The defendant has got to comply with Labor Code Section 4062, disclosing it to a PQME or AME 20 days prior if you're going to take their deposition. There's a panel decision that says that if you show up and for the first time you're going to spring it on everybody, and let's say you're going to do it because you like this PQME or AME, guess what? He's subject to a motion to strike, and alternate PQME or AME could come in. And that's briefed up. I briefed that up 3 years ago, so be aware of that. So the way that I look at it is I never disclose, these are general rules, prior to the deposition if they're relevant. I think about disclosing after the deposition. I often wait until after the medical legal. But at that point, I'm sitting down and I'm trying to fashion a resolution. And I want you to think about why it is that I play it that way. What's my job? I don't care if I have surveillance, if the applicant lies or tells the truth. It doesn't matter. Because if the surveillance are relevant, it's going to reduce the PD. And isn't that my goal or objective? Close the file, reduce the PD. And I've said this all the time. I had a really bad case. Oh, crap. I'm not going to tell any more stories. Okay, that's the Barber case. Because you know what? I want to get and touch on the Guzman cases. Let me tell you, there is a denial of care treating outside of the MPN on page 14, this Kim case. Be aware of that. If you're not compliant with your notices on the MPNs, that can constitute a denial of care that will allow the applicant to treat outside of the MPN. My thoughts on MPN are pretty simplistic. There are as many bad doctors within the MPNs as there are good doctors outside of the MPNs. And fighting over MPNs, what the defense attorney should fight over is getting the best, most competent, fair to both sides doctor treating the applicant. That should be what we should be looking at, in my opinion. I'm not going to touch on that. Real quick on Navarro. Everybody's aware of Navarro. And I'm going to give you a real simple rule. At the time that the applicant is examined by the PQME or AME, At that time, all issues are resolved. The only time that you get a second PQME is where there's a subsequent injury. And then either party can request an alternate, usually in that situation. So it's a timing issue. What Navarro stands for is that you have to go back to the doctor if it's an issue that was in existence and or addressed originally at the original examination. So they addressed everything going back. Navarro, of course, was a subsequent injury, and they were able to get a subsequent medical examination. And that door swings both ways. It's often a really good, and I want to make one comment about AMEs, okay? We're going to go back to the Venn diagram. Remember high school, college? This is my philosophy on use of AMEs, and I have clients that say we will not use AMEs. And I tell them this, listen to this, you have a Venn diagram. In my universe, you know what I have? I have all QMEs licensed in California. The first question is, how would you organize their predisposition? Are they more often than not liberal or more often than not conservative wipeouts? They're doctors, come on, they want to treat. Of course they're more likely to be liberals, okay? How many? 2/3? 3/4? I'd say 2/3. So that leaves a third. Now think about this the way a defense attorney, that leaves a third that are competent, well, that are conservative, a third that are conservative. Of that third, how many of them are competent? Half? Okay. So now think from the defense perspective. I got a 3-member panel in a universe that I've just described, where only 16% are going to be acceptable to me. What are the odds that I'm going to pull a panel where not 1 but 2, because I need 2, right? Because the app attorney is going to strike 1. I need 2. How often does that happen where you have a 1 in 5 to a 1 in 6 chance? Let me tell you, about every 18 or 19 times when you do the calculation, the worst cases that I've had are PQMEs that are true believers. And I don't care on which side they are. The wipeout doctors are no worse than the ones that want to give the applicant everything that they can, okay? So that's my philosophy. And people that don't want to use AMEs, I'm at that age where I just kind of... Anyway, let's skip ahead. Guzman, real quick. I want everybody to know this. There's a couple of Guzman cases. I'm not going to go through it, but you need to understand this about Guzman. Number one, a doctor should always address the issue of Guzman. In every report now, he needs to address the issue of Guzman. It doesn't mean it applies, but he should always address it. What are the requirements under Guzman? Number one, the doctor has to do one of two things, the first step. He has to either provide you the standard rating under the standard method chapter or table within the 5th edition of the AMA guides. These are all cases. Each one of those are cases that have come down, okay? So he has to go ahead and he has to provide you with a standard rating. Number two, he has to address, and this is where he addresses Guzman, whether or not that standard rating is accurate, i.e. complete. In the Cannon case, for the first time, I've been using complete for years. Whether or not that rating is complete. If it's inaccurate or incomplete, he goes to the third step. He says Guzman applies, and I'm going to go ahead and Jake and Mr. Marcus just walked in. I said a lot of bad things about both of you, so don't worry. Anyway, so the first thing, standard rating and standard method chapter or table. The second thing, he has to address whether or not it's accurate or complete. If it's inaccurate or incomplete, he's free to do the third. Now, focusing on the ADLs, not work preclusion, focusing on the ADLs, he's free to use an alternate method chapter or table, but within the 4 corners of the 5th edition of the AMA guides. But the issue here is he has to explain why he's doing it. He has got to provide a rational description of why he's actually doing that, okay? And all these cases, we've had a number of panel cases that have come down, and they right to a T all turn, and people say, well, I don't understand factually. No, it's substantial evidence. Did the doctor and did the judge write an opinion? Because it's important that the WCJ write an opinion explaining why it constitutes substantial evidence, okay? I'm not going to go through subjectives, objectives. I know that they are on whether or not Cannon applies. But I want to go through Ogilvie real quick. How long do I have? I think I have till... How much time do I have, ladies and gentlemen? How much? Okay, I have 15 more minutes. We're going to fly. Ogilvie. I have 2 cases that are important Ogilvie cases. And there are 2 words that we want to take away from this conference. Number 1, the word is synergy. synergy, because both these cases discuss the concept of synergy, both the Barrett case and the Pride and Joy case. Secondly, we want to understand what is meant by, in the Barrett case, Ogleboof. Ogleboof. What that means is, and here's what Ogilvy stands for. Let me ask this question from the doctors in the audience. Is it appropriate for a doctor, and I don't want to put anybody on the spot, is it appropriate for a doctor to express an opinion on VR? On VR, whether or not this applicant has the ability, given the disability, to work? The doctors say yes. You know why? Because what's the joke about doctors and God? We've all heard it. Okay, I'm going to make it real easy for you. No. No. The doctor discusses medicine. The doctor discusses WPI. The doctor discusses work preclusions. You get the VR expert to translate that all into what occupations, what work they cannot do, how it impacts on their DFEC. That's what these cases are saying now. And Ogilvy, in a nutshell, is just simply this. The applicant attorneys go out and get a VR expert to translate what the doctor has said by way, and this is the one area where work preclusions and certainly ADLs come into impact, but perhaps old work preclusions. And he takes all that disability and he translates in how it's going to impact in the applicant's ability, diminished future earning capacity. And that percentage, under the Dahl decision, the Barrett, the Pride and Joy, that percentage becomes the disability award. Do you see why I say that when I heard that Ogilvy was gone after 1/1/13, that it was dead, is not right? Now, I will tell you, there's a burden of proof argument here, because they've gone ahead. What happened in 1/1/13? They increased the DFEC, the scheduled, to across the board 1.4. And 1 point on that, you think about it, that takes a 50% to a life pension. That takes a life pension almost to 100%. So it's huge. That's a huge modifier. So maybe in that respect, Ogilvy is some of the teeth are taken out of it. The Barrett case, I want you to, well, actually, this is not that fun of a case, but they talked about the synergistic effect, given all the dates of injury and all the problems. The fun case, I think, from my vantage, is when an applicant who's been a rock and roll player for all his life decides that he's 100% disabled. Why? Because the diagnosis is tinnitus aurorium, hyperacusis, and misophonia. What does that mean? That means it hurts when I hear, I don't like to hear, and I'm afraid to hear. And what they said here was this applicant, after they looked at the synergistic effect of the narcotics that he was taking, of the psychiatric component, of the physical loss of hearing, was 85% disabled, applying an Ogleboof analysis. Now, one comment on this, and I don't like to Monday morning quarterback anybody, but what should the defendant have done? It's a hearing loss claim. How do you reduce hearing loss? How do you take away the misophonia, or at least the tinnitus? There are medications out there, but what about getting them into the workplace with electronic ears? And there's nothing in this case that, and the reason I thought about that is under the old schedule, we used to, hearing loss was rated corrected, right? And I'm thinking, well, hold it, he's 85%. A large portion of that is the loss of hearing. Why didn't the defense attorney do something in that regards? Hey, this Sutter case, all three of these cases also discuss drug addiction, narcotics, prescription meds. And the Sutter case discusses synergy and how narcotics can make somebody 100%, or at least in the life pension. This, the case on page 23, Benavides. This was a case, I was in a courtroom, it came down, and a judge came to me and said, hey, what do you think about this? What happened here was, the issue was whether or not, there was a stipulation with request for award. It didn't include the impact which a nerve conduction study or something would have on the overall disability, okay, which had been done previously. It was approved, then subsequently, the applicant wrote for clarification and had a higher level of PD. They wanted to file a petition to reopen, and the issue was, hold it, that evidence was available originally. Is it subject to a petition to reopen? They said it was, and let me tell you what my reading of this case is, okay? It's not a get out of malpractice free case. What I think it is a case that allows the WCJs to do substantial justice. And there was essentially a oops moment. Some people screwed up, the doctor screwed up. Now, I also understand certainty, because on the defense side, we want certainty. Once we stip, we're done, at least at that point in time. If it's a stipulation with request for award, it's still subject to a petition to reopen. But we should be done at that point, right? But you can read that decision, just be aware of it. Psychiatric injury. What's been all over the board is what is meant by sudden and extraordinary. I'm on page 24 right now. Sudden and extraordinary. I'm not even going to go through that. You guys can read it. I'm going to give you a couple of rules. If you fall from it, it's probably not extraordinary. If it falls on you, it may be extraordinary. The other thing that I would say is if it's a risk associated with, yeah, aren't you a butt? What a smart butt. Okay, I want to know at that table how much money how much are you paying him for him to do that? Did you all ante up $20?
That was free.
Okay. Can I get a copy? Anyway, I lost my train of thought. Let's talk about TD real quick, and we got through the psych. You can read that. TD, this Bauer case is kind of factually 2 strikes and you're out. This was not even 3 strikes to the. Let me tell you what happened. There was the applicant was injured in 2005. The applicant received TD until 2007. The applicant was P&S'd, 2011, let's say. Okay? The applicant post P&S was determined by everybody to be 100% disabled. 2 issues. Do you have to go back and pay PD at the TD rate going back to the last payment of TD? Or when the applicant became permanent stationary, number 1. And number 2, when do you start the COLA calculations? Do you start them the January after the last payment of TD, which would have been 2007, or the January after the applicant becomes medically permanent stationary? Defendant lost on both. What they said was, once you end with the ending of TD, arises the obligation to provide permanent disability. So you go back, retro it back, and you start the COLA calculation. If you think 5 years of COLA calculation doesn't make a huge difference at the back end, you are wrong. Undocumented workers, I'll let you take a look at that. I wanted to get to UR IMR, and I just have some comments on that. Of course, we had Dubon that came down and went all the way up. It is the law. Let me tell you about Dubon real quick. The carrier went ahead and UR'd a request. I'm going to make it through. The carrier went ahead and UR'd a need for surgery, but the carrier didn't send all relevant documentations. There were some, and records, there were some diagnostic studies that the carrier did not send. The UR was denied. It was not certified. The issue is, what does that mean? What can the applicant do? Less than complete, arguably, factually, medically, that UR determination is flawed. Can the applicant attorney file for expedited hearing and take it before the WCJ? Or is their only avenue of appeal to file for IMR? What Dubon says is they have to go to IMR unless there's a timing issue. And the timing issue, Bowden's in there too. The timing issue can either be the initial request, the 514 day, that initial period, okay? Or it can be the notice requirements. That's what Bowden said. In which case you can go ahead and have issues of medical necessity decided before the WCJ. Everything else goes before the IMR. Now, I'm going to tell you, and I know Jake doesn't agree with me on this. I don't mix words. I don't like Dubon, and I'll tell you why I don't like it. If I'm going to win, I want to win on the merits. I don't want to win because I slipped a Mickey or there was an oops. And of all the benefits, the most important benefit to the injured worker is medical treatment. And all this does is it takes away any incentive to not screw up, and it places the burden on the applicant attorney. Now, because of this, I did some research, and you'll see it in a box in there. There is no reg or statute that precludes an applicant attorney, as far as I know, that precludes an applicant attorney from going out and generating additional medical evidence in between. Hey, what's going on? You want to get that? I'm kidding. You know, if you come to this and you can't have fun, come on, right? Anyway, on the IMR portion, there is no, when the applicant attorney files the appeal or the improper, there is no reg or statute that precludes them from going out and generating post-UR until, and Jake, you tell me, I researched this, I can't find anything, until, he's agreeing with me, until the IMR, that 30-day period. So you can go out and you can write for clarification. You can say, hold it, you didn't send everything. Mr. IMR, take a look at all this. Now, I'm going to tell you something else. There are 2 cases in the 3rd District and 1 in the 1st District that are coming up on the constitutionality. They're challenging the constitutionality of the IMR process. And when the IMR process came down, I told everybody, there's no way it's constitutional. I believe there has to be, and some people will say, due process, what processes do is the issue. As long as you have some process in this type of a scheme, guess what? It's going to be upheld. I don't think that's the case, because it's an important benefit, and because I think a collateral or a corollary argument would be that Dubon allows garbage in, garbage out, up to the IMR, and if you don't do your job, you can be denied that benefit because you haven't had an opportunity to get the applicant hasn't had an opportunity to get the appropriate information before, or cross-examine, or find out what the basis of that. And I'm hearing stats, 84 or 87% of all non-certs are being upheld on IMR. So now, before all the applicant attorneys say that's atrocious, realize your Venn diagram. Which ones are being non-cert? There's a lot of medical treatment that's being authorized without UR. There's a lot of medical treatment that's being authorized that's certified under UR. So the only ones that are going up are the ones that are not certified. And as a universe, those are probably questionable treatments. So that certainly is going to skew up the stats higher. You know, you always want to ask yourself, what's behind the stat, okay? And so this group of treatment, as it goes up to the IMR, is probably more likely than not questionable. So, okay. And I thought we weren't going to do it. I skipped over some of the cases, but I think everybody can read those. And that concludes it. Okay.